Biggest mistake most people make in my industry is that they're not in a hurry. And what I mean by that is we represent people who have suffered a tremendous loss, whether it be the loss of a loved one, their husband, whether it be a personal loss that led to $200,000 of medical bills. And they are owed that by the negligent party. And most often it's the insurance company for the negligent party. And every day that goes by is a day that the money that should be in their account, paying for medical bills, paying for the expenses of life, is in the account of an insurance company earning interest. And it just amazes me that lawyers on our side aren't pushing their cases faster. Some lawyers will sit around, look at a case, investigate a case, and not file it until the 2-year anniversary. Well, we get a case in, we look at it, we investigate it. If it's a good case, and it looks obvious that we're not going to be able to settle it soon, we go ahead and file the case. Let's file a lawsuit. Let's get cranking. Literally just today, I sent an email to a defense lawyer on a case we filed 2 weeks ago. And the insurance company, I have the adjuster's contact information. I said, hey, we filed the case. Let me send you a courtesy copy. By the way, do you know who's going to defend it? She said, yeah, Michael so-and-so. And so I sent Michael an email and said, hey, man, we got this case. We filed it. It's going to be assigned to you. You may already have it. Go ahead and send me your discovery. And normally they don't have to send discovery until after they answer. So you file a complaint. They have 30 to 45 days to file an answer. Then sometimes they file discovery with that. Sometimes they wait 15 days. Then they send us discovery, which are written questions, written requests for production of documents. We have 33 days to respond to that. And before you know it, 60 to 90 days have passed before we've gotten any meaningful information. So I sent this lawyer an email and said, hey, go ahead and send me the discovery that you want us to give you. We'll get to work on it. Even if you don't formally serve it for another month, let me know what you want to know. We'll get working on it so that when you file it, you formally serve it on my client, we'll have you a response within 2 or 3 days. And I also said, go ahead and give me dates for your client's depositions. Let's go ahead and circulate dates for my client's deposition. I want to take the cop's depo, the witness's depo, the treating physician's depots. We can wait on those, but let's go ahead and put that on the list. And let's get on a call in the next couple of weeks and go through a discovery plan so we can work this thing up. It just amazes to me how 6 months can go by after filing a case, and most lawyers don't even know much about their case yet. They haven't pushed it. I think most cases, there are some exceptions, a product liability case, really complicated cases, but most cases should be able to thoroughly complete discovery in 6 months. And you should be able to go to the court and say, all right, Judge, we've taken all the depots, we've talked to all the witnesses, we've gotten all the documents. Now we're going to go try to mediate and settle the case. And if not, in a couple of months, we'll call you back and say we're ready for trial. We have a rule in our office that almost every case, except the exceptionally complicated case, should be stipulated to the trial calendar. We should be telling the court 12 months after the case walks in the door, we are ready for trial. And if not, somebody's not working hard or fast enough. So that would be, I think, the mistake that most of our competitors and colleagues make, is just not acting with a sense of urgency like they should.